the courts. Do you agree or disagree, and why? What are the advantages and disadvantages of an appointed life tenure branch of government overturning laws passed by a democratically elected body of government? When you're ready, you may begin.
In Federalist 78, Alexander Hamilton defended judicial review by writing, "A constitution is in fact and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning." Although the power of judicial review is not explicitly stated in the Constitution, judicial review is apparent in the ideals outlined in the Declaration of Independence by checks to the power of the legislative and executive branches. The institution of power to interpret law should come from an unbiased and just source, something imperative to a functioning Republican democracy.
Hamilton was also correct in claiming that judicial review is a key part of maintaining proper checks and balances to legislative and executive power to ensure the Constitution remains the supreme law of the land. Supreme Court rulings dictate the flow of legislation in the United States. Thus, judicial review illustrates constitutionality within disputed federal law. Sparked by the Judiciary Act of 1789, Marbury v. Madison led Chief Justice John Marshall to explicitly dictate judicial review by asserting that it is emphatically the province and duty of the judicial department to say what the law is.
During the case, Marshall declared the act of Congress partially unconstitutional. Therefore, Marshall set a precedent of judicial review through rulings of the Supreme Court. Justice Marshall's reasoning is best illustrated in Windsor v. United States, where natural rights guaranteed through the Constitution and the Declaration of Independence are applied to equal marriage rights.
Due to the nature of judicial appointment, life tenure is commonly held as controversial, as Supreme Court justices are not directly responsible to the public due to lack of election. However, life tenure guarantees Supreme Court justices a sense of job security and freedom of personal expression independent of public opinion in case decisions.
Life tenure also creates institutional knowledge as best supported by the dissent of Justice Oliver Wendell Holmes in the 1919 case Abrams v. United States, in which Holmes expressed an opinion directly contrasting of his previous majority-supported opinion in Fink v. United States. Life tenure also grants the Supreme Court the ability to operate independently of public opinion. In the recent Citizens United decision, the public is largely unsupportive of the Supreme Court's decision, yet the Supreme Court was held accountable only to the Constitution and precedents.
Institutional knowledge supports unbiased decisions, yet partisanship still occurs within the Supreme Court, as executives often appoint justices with similar political leanings. Justice and executive shared politics are greatest exemplified in the recent appointment of Justice Sonia Sotomayor by President Obama. Life tenure can incur issues with outdated philosophies and a lack of adaptation to public opinion, yet life tenure possesses benefits in the form of protection from political influence and public interference.
Others argue that judicial review is a direct affront to the democratic ideals of the United States government, as the unique election process outlined in Article 3, Section 1 of the Constitution, judges are not elected by the people. This causes some to fear that judges lose their sense of responsibility to the people they are charged to protect. Yet the ability for immunity from public opinion supports justices on making decisions based solely on their constitutionality. Best illustrated by Stenberg v. Carhart in 2000, justices' capability of making decisions against the public opinion strengthens constitutional understanding. Unlike an elected representative, the only constituent the Supreme Court is held to is the Constitution.
Judicial review, though still controversial, is key to our functioning Republican democracy because it offers a check to the power of the legislative and executive branches and ensures that the institution with the power to interpret the Constitution comes from an unbiased source. Thank you.
345.
If you're itching to start, I can sense
Oh,
it.
I'm ready now. Okay, I'd like you to comment on this statement, please. Judicial review, it has been said, is undemocratic because it permits unelected judges to nullify the decisions of elected representatives. How would you respond to that?
I agree with that statement. Justices, due to the Constitution, are not elected by the people. Thus, an elected representative who is supposedly representing the ideas of their constituents through a bill or an act can be shut down by a branch of government that's only held to the Constitution. However, the Constitution is supposed to protect the best interests of every citizen of this country.
Because the judges are not elected, they are allowed more freedom in the way that they rule, as their re-election is not dependent on their rulings. And also, more than the Constitution, they're held to the classical Republican ideal of common good, which is for the majority rather than those that are directly being represented at the time.
I agree with the statement, but it's not necessarily a bad thing that it's undemocratic, because they're upholding the Constitution, which is higher law, meaning that not even the elected representatives of Congress can violate it.
I also agree with James. I think that it is necessary to have some sort of check on the executive and the legislative branch, and I think that the Supreme Court does a great job of that.
Cool, my turn. In the 2000 presidential election between Bush and Gore, do you think the Supreme Court should have stopped the recount even though the Florida state constitution dictated a recount?
I disagree with that ruling. It was a very close ruling, 5-4. The Supreme Court should have allowed a recount as per Florida's constitution. Also, there is a conflict of interest, as the governor of Florida was Jeb Bush, and his brother was running for the presidency. So the Supreme Court should have not stopped that recount. The recount should have happened.
So the Supreme Court violated Florida's 10th Amendment. How do you think that should have been taken care of then?
I think the Supreme Court should have gone along with the recount of votes. In this circumstance, it really was not a constitutional, in my own personal opinion, I do not think that it was a flagrant violation of the United States Constitution, but it was important that we hold the Florida Constitution as law and higher law in this circumstance with the recounting of votes.
I would like to disagree. 5 of the 9 Supreme Court judges ruled against the recount for the purpose that they were following the Constitution of the United States, not just of Florida. They're held to the United States Constitution, not the individual 50 constitutions that the states hold.
I disagree with my colleague.
Whoa.
No,
Keep moving.
you don't want me to answer?
You already talked, she did it, but if we keep going back and forth on that, then we lose the continuity of continuing on to other questions, okay? It's not a who's right, who's wrong.
I wasn't going to
Okay.
do that, but
That wouldn't do good in a competition at this point, okay? So do you want to add, anybody else want to add? Or do you want to move on to another question?
They have my points out there, so.
Okay.
How do Supreme Courts, I heard in the testimony that Supreme Court decisions dictate the flow of legislation. How does that work?
They dictate the flow of legislation in the sense that they're essentially reviewing every act of legislation, because when one that is unconstitutional comes through, they need to review that and determine whether it is constitutional or not.
So, are you saying that every piece of federal legislation that's passed goes before the Supreme Court?
No, but the option is always there if it is can be seen to be unconstitutional.
But how's that? How can
Yeah,
it be
how does
seen
that
to be
work?
how can it be seen to be unconstitutional?
Well, someone would have to bring the case forward against the act of legislation.
So someone would have to believe that it was unconstitutional, right?
Yeah,
And then what's the can you tell me what the process is to get a case to the Supreme Court?
Well, you would have to go through the system of courts,
Starting where?
the federal board.
Any issue or if you want to challenge a piece of legislation?
Is that cool? It has to be an issue that is a redress of grievances. So just because I believe Act 37 goes against the First Amendment, unless I'm actually affected by that act, I can't actually go to the Supreme Court and argue my case. Also, classically and historically, pieces of legislation that are unconstitutional have gone to the Supreme Court because they are very controversial. Yeah, I'm done.
Does the Senate or the House have a right to go directly to the Supreme Court with questions about constitutionality of amendments?
Well, do you mean amendments or pieces of legislation?
Legislation.
There's definitely a system of communication between the houses of Congress and the Supreme Court. It's not like they just hide in their buildings and don't talk to each other, because that's not cool. There's definitely a flow of information. Also, members of the Senate and House should be versed in Constitution and in constitutionality. That is part of, in fact, in the Senate, they have to go through a course of constitutionality. And furthermore, they have legislative clerks in the Senate and in the House that are supposed to check all bills and legislation.
Then why would we need the Supreme Court?
Right.
Well, I mean, of course, not anyone is perfect. There is no perfect system. A legislative clerk could be wrong. There's a lot of issues that could happen. And furthermore, really the Constitution is a document that's up for interpretation. A legislative clerk might think, okay, this is constitutional, but the Supreme Court might think not, based off of their own constitutional interpretations.
So does that mean that the Supreme Court is making laws as opposed to interpreting them?
No.
If, based on what you're saying, if a law is made and then it goes to the Supreme Court, and the Supreme Court goes, no, this is terrible, this is bunk, it's unconstitutional, are they in fact making laws as opposed to interpreting them?
I think I must have been unclear or something. I do not want to argue in any way that the Supreme Court creates legislation, because they do not. I was merely saying that the houses of Congress and the Supreme Court communicate, so it's not a closed house, closed Congress. That is, of course, not when the actual bill is finished, or when they're actually, it's not a bill gets finished and then it's sent to the Supreme Court. If that makes any sense.
I would say that the only type of influence that the Supreme Court has on legislation is setting precedents on their rulings of certain cases. So, although they can't actually make laws or change laws themselves, they can help set up certain directions in which future legislation or future laws may go.
Wouldn't they change law if they deem part of it or all of it unconstitutional based on how it was presented to them? I mean, if you strike down part of it, isn't that changing it?
Changing law does not mean making law. That's interpreting the law as how constitutional, if constitutional it is, and that does not include making it. It just changes the way it affects the people, if it affects the people at all.
Also, the Supreme Court's decisions only state what the issue is with the law in context of the Constitution. It is then turned back to Congress, who can then change the law themselves in a way that would be aligned with the Constitution.
So I'm gonna throw out my favorite question. Then, did the Supreme Court overstep its authority of judicial review with the Dred Scott case? Why or why not?
You guys know the case, right?
You know,
Yes,
hopefully
yes.
you know the case, yeah.
I would argue that they did overstep their power in stating that, black people are not citizens, because in that sense, they are making a law stating that they are not, because they weren't, in that case, they weren't simply interpreting constitutionality of an act of legislation. They came out and said, this is what we think because of it, African Americans are not citizens, and that precedent had lasting effects, much like a law would.
And we're done.
If you have anything to add.
Thank God.
It had lasting effects, caused the Civil War, helped cause the Civil War, sure, that's lasting.
Okay. Breathe.
And we gotta be real brief because we're really 3 minutes over
Tight on
time.
time.
Did someone stop the camera?
Oh, I'll stop. Now, see what we
Hey,
did?
Maddie.
Oh, yeah.
Do you see what we did to you guys?
Yeah.
I mean, it was real simple.